First, it was the Biden administration declaring that highways were racist. Now it's the Biden FCC declaring that the internet is racist. The FCC is specifically considering prohibiting, quote, digital discrimination under a disparate impact standard. Disparate impact is a fringe liberal theory that is not the same thing as discrimination. Far from it. Instead, it deems racist and bigots any individuals or businesses that make decisions that happen to produce statistical differences in outcomes among demographic groups, regardless of whether there is a discriminatory motive. The FCC isn't trying to stamp out actual discrimination. What's really motivating the commission is creating a private right of action to empower trial lawyers and activist states like New York and California to reap millions and millions of dollars in bogus so-called disparate impact claims. If a broadband provider doesn't build out Cadillac-level service to a neighborhood, the FCC and its trial lawyer friends could swoop in and sue, saddling providers with costly litigation, driving up the cost of broadband for all consumers, and sullying the reputation of these companies. Meanwhile, the Supreme Court has made it very clear that agencies can't expand the scope of a statute to impose disparate impact liability or to create new opportunities for trial lawyers to harass private companies. I want to clarify how our nominees view, quote, digital discrimination. Mr. Carr, do you think it is racist if a company decides to build fiber to a middle-class suburb before building it out to a statistically lower income area?
No, Senator.
Mr. Starks and Ms. Gomez, do you agree with Mr. Carr? Mr. Starks.
I would agree with that, yes.
Ms. Gomez?
Yes, Senator.
Okay. Would you also agree that if a company is going to be held liable for discrimination, potentially to the tune of millions upon millions of dollars, based on decisions it has made, that there should be clear evidence of discriminatory motive or intent? Mr. Carr.
Yes, Senator. I think you need something more than mere effect. And just a quick example, you can have two adjacent neighborhoods. We've seen this in our record, LA County and LA City. One had 500 small cells go up, artificial line, the next one had 0. Why? In that circumstance, it was because of the regulatory regime that the two governments put into place. So if you're simply looking at effect and nothing more, I think you would get a misleading view of what happened in that instance and perhaps others.
Mr. Starks?
I would say this, that the digital discrimination item is being considered by the FCC right now. The record is being developed right now. One of the open questions is very much what is the enforcement capacity that the FCC is going to take under this item. We will closely follow the law, but this is very much under consideration right now.
Okay, I want to make sure I understand your answer. Do you believe it is necessary to demonstrate discriminatory motive or intent in order to find someone liable for discrimination?
What I'm saying is one of the things that we are considering is whether there is a disparate impact, disparate treatment versus an intent-based standard that is going to be the threshold that we're looking at on the digital discrimination. What Congress tasked us with is, quote, preventing digital discrimination based upon the 6 classifications that you mentioned. So this item is what we are thinking through right now. The questions that you're asking is what we're working on right now.
So, but if I understand your answer correctly, you're saying no, you don't have to prove motive or intent, that just disparate impact, just a statistical analysis can result in millions of dollars being extracted from broadband providers. Those millions of dollars, by the way, will be paid for by every consumer. The cost of your broadband will go up as the New York Attorney General brings lawsuit after lawsuit after lawsuit, and none of that requires any demonstration of motive or intent. Is that what you're saying?
What I'm saying, Senator, is that the actual issue that you're asking me about, the question of disparate impact versus an intent-based standard, is something we are considering right now as a matter of policy in effectuating the law, the digital discrimination.
Okay, but you're declining to answer my question. Mr. Carr answered it. You're declining to answer. You're not saying whether intent is required or not. You're just saying we're thinking about it, but you're not giving me an answer. It's okay. I'm just being clear. You're not giving me an answer.
I understand. We are thinking about this, and the question of enforcement capacity is one of the things that also is before us. And so,
okay, so Mr. Starks has declined to answer. Ms. Gomez, is intent necessary to find a provider liable for discrimination?
Thank you, Senator, for that question. I am aware of the law. I have not actually dug into the record, but if confirmed, I would be happy to do that and work with you on any concerns you may have.
Do you believe intent should be required?
I honestly don't know enough about this to be able to.
You spent 30 years in the industry, as you told us in your opening. In 30 years, you had no view on...
I have spent 30 years in the industry doing standard telecom work. The issue of digital discrimination is something I know Congress tasked the Commission with looking at last year, but I need to be able to sit down and dig into the record and look at the notice of proposed rulemaking in order to be able to give you an informed answer.
Thank you.